If you have a personal grievance, more often than not, an employer will want to settle the matter outside of court. To do this, they will get legal advice as to what they are likely going to have to pay out for, and will offer to pay you something close to that much in a lump sum of money to get the case to go away. Of course, you can always choose to reject that offer. You might think you have a chance to get more in court, that you can negotiate for more, or you just want to have the matter go to court for other reasons. But rejecting an offer that will cause you to go to court should be a serious decision, as the case of Fagotti versus ACME Co Limited shows, because sometimes going to court can be more expensive than just taking the offer you got to start with. So what happened here? ACME, the employer, owns a cafe in Wellington called Prefab. And on the 9th of February, Mr. Fagotti was called into trial for work at Prefab and was verbally offered a job after completing his trial shift. 2 weeks later, Mr. Fagotti began working there as a proper employee, and on the morning of his first day there, the 23rd of February, he was given an employment contract to sign. This agreement contained a clause that meant he was on the 90-day trial period that would allow ACME to dismiss him without the same formal procedures that would normally be required of them. All was fine until the 12th of March, when Mr. Fagotti was talked to by his manager and told he was going to be dismissed, and no reasons were given as to why. Mr. Fagotti, distressed, raised a personal grievance for unjustified dismissal. Mr. Fagotti claimed that because of his work on the 9th of February, he was already an employee, and so ACME couldn't rely upon the trial period to dismiss him without explanation. ACME, wanting to settle the issue, offered Mr. Fagotti a payment of $3,000 on the 18th of September. This was $2,500 for compensation and $500 towards legal costs. 2 days later, on the 20th of September, Mr. Fagotti counter-offered to settle for $10,000. ACME bounced back and offered $5,500. Importantly, the difference between the two offers was for legal costs. This meant they were offering $2,000 for compensation and $3,500 for legal costs. Mr. Fagotti once more counter-offered to settle for $9,500 on the 1st of October, with the difference between his and ACME's offers being only how much he should be compensated. Mr. Fagotti wanted $6,000 for compensation. ACME gave its final offer on the 31st of October for $6,000, increasing the amount of compensation by $500 up from their previous offer. Mr. Fagotti then responded on the 7th of November, asking for $11,500 to settle the issue now. This went unanswered, leading up to the court date. And then on the 21st of May the next year, 2014, Mr. Fagotti making one last offer before the court date for $17,500, $5,000 for compensation and the rest for legal costs, as given how long things had been going, he was getting quite a large bill going. ACME rejected this offer. Once the matter got to court, Mr. Fagotti was successful in his unjustifiable dismissal claim, and was awarded a total of $8,598 in lost wages and compensation. Mr. Fagotti, however, was now $24,000 in the hole for legal expenses, and that bill wasn't going to cover it. That bill that he received for legal expenses was an extensive list of legal services, including drafting legal documents, correspondence with the other party, preparation for mediation and mediation itself, investigation, and meetings. The question before the court here then is, should Mr. Fagotti, who has already been paid out, get more for his legal costs? So what did the court find? Mr. Fagotti claimed that the previous Employment Relations Authority, where the only thing to be decided was the costs to come out of the dismissal, had been wrong to only award $4,500 for his legal fees, and so came to the Employment Court to review how it had made its decision. Mr. Fagotti was arguing over what was called the notional tariff, or what the courts will call a reasonable amount for a lawyer to be charging per hour. If Mr. Fagotti couldn't be successful in getting all $24,000 he'd spent on his lawyer so far, he wanted to get about 2/3 of the costs. Here they were relying on the law set out in PBO Limited and De Cruz, where the court decided that they could give up more costs if it was what would get the fairest outcome, even if it went against the notional tariff system. Mr. Fagotti argued that the court hadn't considered how he would be affected by just giving out that standard cost level. So what would be fair? Mr. Fagotti argued that the courts should be considering why he had such a large legal bill. He argued that this was because he had to reject offer and offer and offer by ACME, who had not been realistic about the outcome of the case. These would be indemnity costs, awarded when the other party in the case was very badly behaved. So what is the test for determining whether those offers had been bad offers? Well, that's when an offer is made without considering whether the law was on your side and going ahead anyway. Here, Mr. Fagotti argued that ACME never really had a leg to stand on and should be punished for rejecting reasonable offers that he'd made, which dragged out his legal costs. However, the court here rejected this claim, as ACME hadn't been that bad. They'd negotiated on what they thought were their legal grounds. All of this then wasn't going to be enough to push up the costs to the 2/3 that indemnity costs would give Mr. Fagotti. The court had already made a $1,000 increase from the standard $3,500 to account for some of this, and any more wasn't for the court to award. Therefore, no further costs were awarded, and Mr. Fagotti walked away much worse off from this. What are the important points of law here? Firstly, Mr. Fagotti spent quite a bit of money on legal costs. $3,500 should generally be seen as the most you're going to get for legal costs, as this is the amount expected to cover your time spent in the Employment Relations Authority. If you're going to spend more than that, be very careful, as the award you get for compensation could be less than you need to cover your costs, depending on how much higher up you go. Lawyers should also be careful here not to charge more than that $3,500 sum for the same reason. Secondly, the offers made by the employer should be taken seriously. If a court ends up awarding you the same or similar amounts to what an employer offered you before the case, then you could be required to pay out your opponent's legal fees, as well as your own legal fees. Thirdly, costs are always an issue that the Employment Relations Authority will take into account. If you lose your case, you risk having to pay out your employer's costs as well. But if you raise a personal grievance that doesn't have any weight to it, then you risk falling into that bad behaviour category that we talked about above, and be required to pay out even more if your case is seen as too unreasonable. This cuts both ways though. Even though it was unsuccessful here, employers can be hit for being too unreasonable as well. The court will make costs awards when there is more justice in making those costs awards. So if an employer has been rejecting offers for bad reasons, and you have been hurt financially by that, then the courts can order them to cover you for that.